9 voices, 1 ruling, and in a single stroke, the highest court in America just rewired the rules that decide whether you walk free or never walk again. It wasn't a compromise. It wasn't political theater. It was unanimous. 9 justices, left and right, stood together and ripped apart a legal standard that's haunted this country for decades. For years, the system hid behind snapshots, freezing the last seconds of a deadly encounter and pretending that was the whole truth. The excuse was always the same: I feared for my life. And in that frozen frame, context vanished. What led to the confrontation? What mistakes pushed it toward tragedy? None of it mattered, until now. Because in this ruling, the court didn't just change the angle of the lens, they widened it. Suddenly the entire chain of events mattered. What was said, what was ignored, what could have been avoided. And here's the part that no one expected. The case that forced this constitutional reset wasn't some high-profile standoff. No bank robbery, no mass protests. It all began with something so routine, so minor, that it should have ended with nothing more than a citation. It all began so small you'd almost laugh if you didn't know how it ended. Not a high-speed chase, not a hostage crisis, just a toll violation. A few unpaid dollars that should have meant a ticket, maybe a court date at worst. But that night, those few dollars lit the fuse on a tragedy that would climb all the way to the Supreme Court. Ashton Barnes sat behind the wheel of his car when Officer Robert Felix pulled him over. At first, it looked routine. Orders given, compliance shown. The kind of exchange that happens 1,000 times a day. But then, hesitation slipped in. Barnes cracked the door like he was stepping out, and then changed his mind. He hit the gas. That's when Felix made the decision that would haunt every courtroom after. He didn't step back. He didn't regroup. He leapt onto the moving car, clinging to the frame as it rolled forward. In less than 5 seconds, 2 shots tore into Barnes. The car staggered to a stop. Barnes' life was gone before anyone could even process what had just happened. And yet the real shock wasn't the shooting itself. It was how the courts chose to explain it away. When the dust settled, you'd think the courts would ask the obvious questions. Why leap onto a moving car over a toll violation? Could this have been stopped before it ever turned deadly? Was the officer's fear in that instant real, or was it the result of his own reckless choice? But none of that mattered, because for decades, judges had relied on a shortcut. They called it the moment of threat, and under that rule, the only thing that counted was the split second before the trigger was pulled. Not the lead-up, not the mistakes, not the escalation, just that frozen instant. If an officer claimed fear, that was the end of the story. 2 seconds of panic erased every detail that came before. The lower courts looked at Felix clinging to the moving vehicle, circled that frame and said, "Justified. Case closed." Think about what that really means. By that logic, anyone can create the danger, claim fear in the final heartbeat, and walk away shielded by the law. It wasn't just a loophole, it was an escape hatch. One that slammed shut on accountability again and again. But this time, the Supreme Court wasn't buying it. And here's where everything flipped. Because while the lower courts were content to freeze the frame, the justices of the Supreme Court saw something far more dangerous. A standard so narrow, it was erasing the Constitution itself. For the first time in decades, all 9 justices, every single one, agreed. Fear alone could no longer carry the weight of the law. The moment of threat doctrine was dead. In its place, the court laid down a new command: the totality of the circumstances. That means no more tunnel vision on the last second of chaos. Now every choice leading up to the use of force matters. Did the officer follow procedure? Did they escalate when they could have slowed things down? Did warnings get ignored, or opportunities to de-escalate tossed aside? All of it goes under the microscope. And the ruling didn't hedge or soften. It was written in stone. Context counts. The entire chain of events is the law of the land. What does that look like in practice? Imagine a courtroom where the tape doesn't stop at the gunshot. Instead, it rewinds to the very first command, and judges are forced to see the full story. And that's where the ruling stops being abstract law and starts crashing into your life. Because this wasn't just about Barnes, it's about you, especially if you own, carry, or even plan to. Picture the scene. You're pulled over late at night, seatbelt on, hands steady on the wheel. You calmly say the words every responsible carrier has drilled into memory. Officer, I'm legally armed. Under the old rule, none of that mattered. If things went sideways, the only frame the court cared about was the last 2 seconds. If the officer said they were scared, your calm compliance vanished in smoke. Not anymore. Now the full record follows you into court. Judges must weigh whether you obeyed, whether you stayed calm, whether the officer escalated instead of diffused. That simple shift could mean the difference between a tragedy pinned on you and the truth finally being heard. And it doesn't stop with traffic stops. Think of no-knock raids gone wrong, mistaken addresses, plainclothes officers storming a home. Before, courts cropped the story to the flash of gunfire. Now, every reckless step that led there gets dragged into the light. This isn't theory, it's survival written into law. Now bring this closer to home. Imagine a no-knock raid at the wrong address. Under the old rule, all the court saw was the homeowner firing back in panic. Today, everything counts. Whether officers identified themselves, whether the address was confirmed, whether escalation could have been avoided. Or think of a red flag order served at midnight. Before, the tape froze at the moment you reached for your holster. Now the full story comes in. The warnings shouted. The compliance showed. The fear you faced. Even a routine traffic stop feels different now because your calm actions can't be erased by someone else's last-second panic. For gun owners, that's not theory. That's survival written into precedent. And if you think this ruling only lives in dusty law books, think again, because the shockwaves are already tearing through police departments and courtrooms nationwide. Cases once pronounced dead are clawing back to life. Families told, sorry, case closed, are reopening files with brand new teeth. Lawyers who hit brick walls for years now walk into court with the Supreme Court standing behind them. And the departments? They know the ground just shifted under their boots. The old playbook, say you were scared, freeze the frame, walk away, is gone. Training manuals have to be rewritten. Policies gutted and replaced, because now, one reckless move at the start of a stop could poison the whole defense at trial. Even qualified immunity, that shield officers use to block lawsuits, has cracks running through it. For decades, courts said you couldn't sue unless a right was clearly established. But if the only moment that counted was the gunshot, everything else stayed hidden. Now, the timeline is wide open. Missteps once buried in the shadows are suddenly evidence. The system is bracing, but make no mistake, the floodgates are open. And the ripple effect doesn't stop at the police academy. Courtrooms across the country are already shifting. Hundreds of cases dismissed under the old freeze-frame rule are crawling back from the grave. Families once told justice isn't possible are dusting off files and filing fresh motions. Judges are rewriting jury instructions. Appellate courts are tearing out pages of precedent. Even prosecutors are nervous because cases they thought were slam dunks now look shaky when the full timeline gets dragged into the light. For the first time in decades, the balance of power in these trials isn't tilted completely one way. And that balance shift isn't theory. It's happening right now. And here's where the earthquake hits hardest, right at the collision point of the Second and Fourth Amendments. For years, courts treated these rights like they lived on separate planets. One was about owning and carrying, the other about searches, seizures, and force. But anyone who's ever been pulled over while carrying knows the truth. Those rights are chained together. Because what good is the right to bear arms if the instant you exercise it, an officer's panic can erase it? If the simple act of saying, "I'm carrying legally," gets twisted into a threat in the final 2 seconds of chaos, that illusion is gone now. The court finally admitted what gun owners have known all along. Your Second Amendment means nothing if the Fourth can be cropped down to a single heartbeat. By forcing judges to weigh the full story, both protections lock together like armor. Lawful carry is no longer presumed dangerous by default. Calm compliance, clear words, even a visible holster, all of it now has weight in court. And that's a tectonic shift. For the first time in decades, 2 core rights don't just coexist, they reinforce each other. So what does all of this mean going forward? It means the ground has shifted, but the battle isn't over. Because the same system that leaned on fear for decades will be hunting for new excuses tomorrow. They'll test the edges, they'll probe for loopholes, they'll try to claw back the power they just lost. And if citizens stay quiet, those cracks will widen until the whole victory crumbles. That's why this ruling matters to you. Whether you carry every day or never touched a firearm in your life, it's not about politics, it's not about left or right. It's about whether your rights vanish in a flash of panic or survive because the full truth finally counts. So here's the warning. Stay sharp, stay informed, and don't let this moment slip into silence. Talk about it, share it, because this wasn't just another court case. This was a reset. A unanimous court correction that redefined what justice means when lives are on the line. The story is still being written, and the next chapter isn't up to the court, it's up to you. Because silence is the one thing this system counts on. The ruling was unanimous, but the fight? That part starts right here with us.